Hey guys, and welcome to today's video. We've got a couple of court cases to cover. The first involves a pro se defendant who genuinely believes he understands the law better than trained attorneys. The second features a self-diagnosed insane sovereign citizen who goes head-to-head with a new judge and leans into the only defense that might actually work. Pleading insanity. We'll start with a sovereign citizen, who conveniently gives us two hearings to review, one from about a month ago and another from yesterday. So, let's get into it.
I'm turning to Ronald Hargrove.
Jonathan Baber on behalf of Mr. Hargrove.
All right. Is Mr. Hargrove here?
I do see a Ronald Hargrove name. There we go.
Okay.
Judge.
I think I just heard him. He's coming on. All right. Okay,
Thank you, Your
Mr.
Honor.
Hargrove. Go ahead, Mr. Baber.
Yeah, today is the date and time set for a couple of things. It's a status conference, Judge, but it's also a hearing date for my motion to withdraw. I'm really just going to rest on what I put in my written motion for this court. I really can't disclose too much more in regard to what the conflict is between me and my client without risking attorney-client privilege, and I don't want to waive that on behalf of Mr. Hargrove. But I do believe there's been a breakdown in the communication between me and my client. We just aren't seeing eye to eye on certain aspects, and I want to respect his wishes on how he wants to have his case represented. So therefore, I'm asking this court to consider withdrawing me from the case.
All right. Mr. Hargrove, well, first of all, Mr. Baber, you are appointed to represent him. Is that correct?
I am.
I do see that in your motion. Okay, give me just a second to.
And I want to stress to the court, too, that Mr. Hargrove has been very respectful. It's just a situation where we just do not see eye to eye on certain things.
All right. So, Mr. Hargrove, you understand what, without getting into details, because I've read the affidavit of Mr. Baber, but do you understand what he is saying?
Yes, sir.
All right. Now, if I allow him to withdraw, which is what I'm leaning towards right now, I'm not sure whether there will be another attorney appointed for you or not. I don't know.
No, I was just confused about a bunch of things.
Right. But, when there's a significant disagreement as to how to proceed, an attorney cannot go ahead and present something to the court that the attorney believes is not justified by law or fact, even if his client thinks it is. So he can't do that if he believes that's against the rules that we have to practice under.
Okay. Well, let me ask you a question.
But you can ask it. I'll answer it if I can.
Are you the trustee for the Sesta KV account, Ronald Gene Hargrove II, or any account thereof?
Are you asking me that question? I have no idea what you're talking about.
Sovereign citizens believe that naming the judge as trustee of their supposed SSQV trust creates a conflict of interest. It doesn't. The judge is not your trustee.
You don't know
I
what I'm
suspect the answer is no, but we're really not going to go down that road. Right now, the only question is whether or not Mr. Baber should be your attorney or not. He's filed a motion to withdraw saying that he can't. Basically, you have a disagreement on how to proceed. That's too significant for him to proceed.
Okay.
All right, so I'm going to allow him. Mr. Baber, was there an order that accompanied your motion?
No, Judge, I will prepare one and present it to the court by tomorrow.
All right, that's fine. I'll go ahead and sign that. Mr. Hargrove,
Yes, sir.
you wish to have another court-appointed attorney?
No,
Or do you want to represent yourself or hire your own attorney?
well, I guess I'm not going to get anywhere. No, my questions aren't being answered. So I don't know what to do.
Well, I need an answer. If you want to request another attorney, I can have you interviewed again by MIDC. They may or may not appoint an attorney for you or allow one? What do you want to do?
Well, um, uh, I guess I'll go forward with an attorney and
Okay,
because
so
I
here's,
I have a, a witness and some other things. So
okay,
I guess I need an attorney.
There's no guessing here. You're not equipped to handle subpoenas or evidence on your own. Stop firing your lawyers and let them do their job.
well, I mean, it's up to you. I'm not necessarily going to appoint one for you. Ms. Parker, is Mr. Brown there?
Yes.
He is. He just popped on. Mr. Brown, this is a bit of a new one on me. I don't know if you heard it all. Mr. Baber was appointed to represent Mr. Hargrove. He withdrew because they had some disagreement on what should be presented to the court. And I've allowed the withdrawal. Mr. Hargrove still wants a court-appointed attorney. Does that have to go to Mr. Slough, or is he simply re-interviewed by you?
I don't necessarily know if he even needs to be re-interviewed unless things had significantly changed, as he did have a court-appointed attorney. So unless things have significantly changed, I don't think a withdrawal would require a re-interview. I think he would just have to be appointed another attorney.
All right, so we'll notify Mr. Gilo's office of that. Mr. Hargrove, that attorney would be appointed for you. You'll be given the name and number of that attorney. You should give them a call. Pam, if you call, or that attorney, would you also let them know they may want to call Mr. Baker?
I'll try to remember.
Yeah, okay, I
Yeah.
get it completely. But Mr. Hargrove, I suspect that if this attorney has the same situation that Mr. Baber does, you may end up representing yourself or having to hire your own attorney.
Well,
Okay.
I wish you would just please answer my question.
Well, that's nothing that I can answer in a situation like this. The only question, you need an attorney, you've requested an attorney. If the next time you come to court, I won't be here because there'll be another judge. As my term ends at the end of this month, in about 10 days or so, 12 days. So any argument would be presented to them, but it has to be done according to the court rules that we're all bound by.
But you don't have to answer my question?
No, he doesn't. He's retiring at the end of the month anyway. Judge Hesseling took over Judge Cooper's bench about a month ago and is already dealing with his first sovereign citizen case. Even with a lawyer, the defendant still manages to hurt his own position.
All right. Ronald Hargrove, file 24-43189 ST. I see you, Mr. Hargrove, on Zoom. You represented by counsel, Mr. Hargrove?
I represent Mr. Hargrove, Judge.
All right, thank you.
What we're going to ask the court to do is accept the plea to count one with the second offense dismissed.
Mr. Fortier, is that an accurate statement of the agreement?
I don't know yet, Your Honor. I can't find the case for some reason.
All right, I'll give you a second.
Mr. Gilo, did Miss Brooker email you that offer?
Yes, on the 9th.
Okay. Then yeah, Judge, that would be what we're gonna do then.
All right. Mr. Hargrove, you've heard the attorneys talk that there is an agreement being offered to you that if you plead guilty to the first offense of operating with your license suspended, the notice for second offense, which enhances the penalty, would be dismissed. Is that what you want to do? You're on mute now, Mr. Hargrove. You're going to have to take your, there you go. Is that what you want to do today? I'm sorry.
I just had a few questions.
Well, you're going to need to talk to your attorney about those questions. Do you need some time to do that?
he can't answer them for me.
All right, well, then what are your questions? Let me see if I can answer them for you.
Okay, well, I don't understand how you can be the trustee of my Cesta KV account, Ronald Gene Hargrove II, and not have my best interest.
I'm sorry, what, I don't understand what your question is.
How can you be the trustee of the Cesta KV account, Ronald Gene Hargrove II, and not have my best interest?
What is that account that you're referring to?
Oh, God. The Cesta
Yes,
KV
it is,
account
but
that
go
everybody
ahead.
most people have, and you're the trustee, just like the Secretary of State is trustee of it. You are my trustee, aren't you?
No, and neither is the Secretary of State. The new judge is managing this oxygen thief fine. I'm to ask the 93-day question. Do sovereign citizens ever want a real case with their huffle-duster arguments?
Not that I'm aware of.
Oh,
Why would I be your trustee? Mr. Gila, do you have some additional information that I'm not picking up on?
No, Judge.
it's just something that I believe in, and I've seen evidence of, and
What leads you, Mr. Hargrove, what leads you to believe that I'm your trustee?
because of a former case I've seen.
A former case, what former case are you referring to?
In Roscom, and a friend of mine asked the judge that, and he couldn't answer him. So
That's probably because it's not factually true. What information do you have that leads you to believe that I'm a trustee for you?
In that case, the judge quit 6 months into his new term because he was dishonored, and the sheriff.
Sheriff citation? Show me proof before I believe some hillbilly sovereign citizen found a loophole and got a judge and sheriff fired.
So,
Mr. Hargrove, the question was not about a Roscommon County case. It was about this particular case. You've alleged that I'm your trustee. I'm asking what information or proof that you have that is true.
so you're just denying it?
I don't know of any information that it makes it true.
Okay. If it was
what information do you have?
If it was a misdemeanor,
go ahead.
If it was a misdemeanor, would it be true?
No. Misdemeanors and trusts have nothing to do with each other.
Okay, well,
there has to be some court order for me to be a trustee for you. For anybody to be a trustee, there has to be a court order. Do you have such a court order?
No. I just believe that you are my trustee of the Cesta KB account, Ronald Gene Hargrove II, and that's.
Could you speak a little more clearly and tell me what that account is?
I'm not sure. I just believe that you are my trustee, and if you deny it, then you deny it. Okay, we'll move on from there. I guess, and another thing is I paid $1,000 for a reinstatement fee, but you guys keep saying I don't have a license. And where did my $1,000 go? I don't understand this.
Who did you pay $1,000 to, Mr. Hargrove?
The Secretary of State or the
Then you
state
need
of
to ask the Secretary of State.
Well, I believe I have my license, and they just there's a screw up somewhere.
Then you need to contact the Secretary of State, but I'm not connected to the Secretary of State. I'm the court system. I work in the court system. I don't work for the Secretary of State, so I can't tell them what to do. If you believe that you paid the money and you should have a license, you need to contact the Secretary of State.
Okay. Well, knowing that I think I had a license at the time, doesn't that change things?
It would change things only if it were true, and I don't know that it's true. Just because you believe it doesn't make it true.
Yeah.
Thanks, Judge Hesselink. Less than a month in, and you're already ruining Christmas and Easter for some gullible folks.
All right, Mr. Hargrove, your attorney has told me, and the prosecutor has agreed, that there is an offer on the table for you to plead guilty to operating with license suspended in exchange for dismissal of the second offense notice, which makes this a much more serious charge.
Okay.
Do you want to accept that today, or do you want to have some additional time to speak with your attorney?
No, they don't have nothing to say to me. Their best interest is of the court. So I'll take that, and I would hope to get the same fine everybody else did today. Thank you very much.
Well, I can't guarantee that because you're in a different circumstance than everybody else.
Well, I'm pleading guilty to the same offense they just pled guilty to.
But your background is not the same as theirs.
You know what? I'll plead insanity.
I believe. The hearing's rescheduled a few weeks out, and the next one's bound to be insane, literally. Next, a young man claims he can prove his innocence with facts and testimony, but refuses a public defender's help.
What's your name?
Oh, you were out for an arraignment this morning.
Yeah,
That was at 8:30.
Yeah, I dropped my son off at 8:30. I didn't know because the court didn't open
Okay,
up
so what
till
we have
8:30.
to do,
So I'm trying to figure out how to get it.
well, I don't think you're gonna,
county.
you're not gonna, I don't think you're gonna, are you gonna have time to address that? You wanna go through an arraignment?
Please. That's fine. Thank you.
Then you go discuss it with Mr. Sierra. What's that?
We talked.
You already talked? All right, well, let me finish.
Form's already submitted.
Okay, let me take care of these here quick and I'll get right to you. Let's go in the record in the matter of People State of Michigan versus Brown, file 2444177FY. And state your name, sir.
Quentin Brown.
Assistant Public Defender Dario Sierra appearing on behalf of Mr. Brown for the purpose of arraignment.
Very good.
We have reviewed that felony file. I waiver reading at this time. I'm speaking with him. He had asked it a set for the probable cause conference in the prelim. After he has just advised now that he would like to self-represent. So court-appointed attorney is being denied by Mr. Brown.
Well, it's not being denied.
He was previously
declining
granted,
to accept it.
so
All right. All right. You sure about that? You want to represent yourself when someone goes to school for many years to learn how?
But I know what's going on better than anyone that can, because it's not right.
You have the right to defend yourself, but that doesn't mean you should jump off a cliff. I get it. You believe you're innocent with proof to back it up. The problem? Court rules are tricky, and lawyers know how to navigate them. That's why judges always recommend a lawyer before anyone tries to go pro se.
It is your right. It's your absolute right to represent yourself. The point of I just want to.
I got proof.
Hold on. Okay.
I just want to talk to the prosecutor in my case.
Okay, and that's fine. I'm just gonna right now, what I say now for the next moment is going to be something I want you to listen to only for the sake of protecting you. The only reason I'm making the statement is to protect you from yourself, which I have to do a lot with people, okay? So this is not just a matter about you, it's about anyone that wants to represent themselves. I go through this with, okay? And what I want to be sure is to not have you make statements right now about the case, because we're on the record and I don't want anything you say now to be able to be used against you as you go forward, okay? That's just to protect you. That's the only reason I'm saying that, all right? What I want to also go into is the fact that I'm going to give you the spoiler alert. You absolutely have a right to represent yourself, so I'm not going to, you're going to have that right. But I want you to be very wide-eyed and thoughtful about whether or not you want to have someone who is, who does this for a living, who is here, they know all of the laws, they know all of the various potential defenses and discussion points that they could have with the prosecutors to probably assist you in using your knowledge. So if you say you know all there is to know about your specific case, and that's probably true, no one would know that better. But if you combine that with the know-how of a prosecutor, of an attorney,
they won't represent me like I'm innocent and protect me like I own my life and my freedom.
My understanding of the quality and caliber of
they offer me deals and the prosecutor and I'll never get the chance to speak to him.
It's a bit tough to hear, but it sounds like he's upset that his defense attorney received a plea offer from prosecution, didn't accept it, and just passed it on to him for consideration, which is what they're supposed to do, that he seems to think the public defender accepted the plea without telling him first. But as you'll see, That's not the only misunderstanding he has.
They have an absolute requirement when the prosecutor makes what is known as a plea deal or a plea negotiation. They have a responsibility. They have ethical responsibility to share that with you. That's your decision, but they have to present it to you, at least for you to make that decision. But when I appoint an attorney to represent you, you're that attorney's boss. And if you decline a plea negotiation, then it's declined. That's up to you, not to them. So, like I said, I'm gonna go ahead and indicate here that you wish to represent yourself. That's fine if that's what you want, but I would be thoughtful about that, because again, this is what they do for a living. You know what I'm saying?
Well, I know in court that they had to find me beyond reasonable doubt, guilty beyond reasonable doubt.
That is
so
true.
I feel comfortable representing myself because I know for a fact I'm innocent and I haven't committed any crimes.
Okay. Well,
so,
and that's fine. We can
else you can represent me, they don't know. They don't know.
Well,
100%.
But
they can go home and sleep and be like, they don't know me. Okay. They don't know.
All right.
If I did these things.
Here's the thing. What happens though at a trial, if you're representing yourself, and again, the end result of this is you're going to be able to represent yourself if you want, but it's going to be not you. It's not going to be a judge, and it's not going to be the prosecutor that makes a decision as to whether or not you are indeed guilty. It's going to be a jury.
I know.
And they're going to have to, and they're
going to be you.
It's not going to be me.
Or whatever it is. I guarantee you will be changing this verdict after I got what I got to say.
I'd be shocked if he tied his own shoes today without Alexa's help. This guy shouldn't be representing himself. Verdicts come at the end of trials, not during arguments. If you think you'll overturn the verdict before then, you're admitting you expect to lose. Get a lawyer.
Okay. The question is, and I don't know what your evidence is, but the thing is, if you have an attorney to assist you, that helps you get that evidence in, because there are some things that cannot be brought into court, and they know those rules. I don't know if you do or not. Maybe you do, but if you do, that's fine. But there are some things that cannot be brought in, things that are considered hearsay, things that don't have a proper foundation, things that may not be authenticated.
Well, cash, like you paying me on the table.
Mr. You're on the record right now.
I don't want you making any statement, sir, that is going to incriminate yourself.
It's not going to incriminate me, sir.
Anything you say, though, sir, can be used against you.
Exactly.
This is a court record.
Yeah, exactly. I just don't want anything.
Do that in court. I'm in court now.
You are in court, and they can use it
my defense. This is what I'm going to use.
That's fine. All right. I'm going to go ahead and indicate that you're declining court-appointed attorney. That's fine.
That's what I'm saying. Like, he right here, you don't want me to get my record across. This is what I'm here for.
Well,
I came good for it because I want to press charges against him. I want to talk to the sheriff after this and Mississippi State Police, and I have my evidence.
This is my concern, is that you don't fully understand the process. And that is not to say that you are not intelligent or anything. This is not what you do for a living. That's why most people wouldn't understand the process. But if you're determined to represent yourself, and I've tried my best to convince you, maybe you want the assistance of someone to help you. But if you don't, I'm going to indicate you're denying the request for court-appointed attorney. Now we have to address bond.
I just don't feel like they would take care of my.
Okay, but that's not been my experience. My experience is that they are very effective. But okay, we have a $2,000 personal recognizance bond, and I am going to continue that. And then now, the dates for the probable cause conference is December 5th, and the preliminary examination, that's going to be December 10th. That's going to be at 9 a.m. That's the prelim. And the probable cause conference that on December 5th, that's at 1:00 p.m. Okay. Now that one you can attend by calling in and discussing the matter with the prosecutor. I'm giving you notice right now.
No, like paper notice.
You're going to get, they'll send notice.
I could forget.
Well, you've got to write it down, because I'm giving you have notice right now, sir. This is your notice. Yeah, so if you don't show up, you're not gonna be able to come here and say that you didn't get the notice, because a bench warrant will
Said
definitely,
9 a.m. for what day?
9 a.m. on December 10, but 1 p.m. on December 5th.
December 10th. 9 a.m. Could this be appeared by Zoom?
The December 5th, you can appear by Zoom. December 10, you have to be here physically.
All right, that wraps up today's video. He had a pre-trial conference on the 5th and a pre-trial hearing on the 10th. That hearing wasn't broadcast, so we're left with 3 likely possibilities. The least likely? That he didn't show up. He seemed pretty invested in the case and confident he would win, so I can't imagine him missing it, unless he just forgot the date. The second possibility is that he had a Zoom call with the prosecutor on the 5th, and they either worked out a deal or the prosecutor reviewed his evidence and decided to drop the case. The third, and probably just as likely, scenario is that after the call on the 5th, they decided to move forward with the trial, but granted a continuance so he could prepare to defend. Himself pro said, I follow this courtroom closely, so if he returns for a future hearing, I'll be sure to keep you updated. Until then, if you liked the video, hit that like button. If you didn't, hit dislike. Don't forget to leave a comment below and subscribe with notifications on so you don't miss any of my content.